My name is Kendry Tan. Today, I want to talk Lex Loci Celebrationis. The Lex Loci Celebrationis is the Latin term of the law of the place where the marriage is celebrated. In the conflict of law. Conflict is the branch of a public law regulating a lawsuit involving a foreign law element where a difference in result will occur depending on which law are applied. When a case comes from before a court and all the main features of the case are local, the court will only apply the lex fori, the prevailing municipal law to decide the case. But if there are foreign elements to the case, the foreign court may be obligated under the conflict of law system to consider first, whether the foreign court has the jurisdiction to hear the case. 2. It must then characterize the issue, allocate the factual basis of the case to its relevant legal classes. 3. Then apply the choice of law rules to decide which law is to be applied to each class. The law of place of celebration of a marriage in private international. This law governs such questions as the formalities required for a marriage are subject to 4 special exceptions, whether or not such marriage is monogamous or polygamous, and possibly what law governs impotence or willful refusal to consummate a marriage. Where is the Lex Loci Celebrationis? Determining whether marriage is contracted may in some instances raise difficulties. Discussion has entered around 3 particular types of case: A. Marriage by correspondence, B. Proxy marriage, and C. Marriage by habit and repute. Let us look briefly at each one of these cases. A. Marriage by correspondence. In the United States, there is some support for the view that a common law marriage may be contracted by the action of consent without any necessity of the parties being physically present together, and that this action may be made by the corresponding difficulties surrounded by the questions of whether a contract is concluded in such circumstances. An issue also arose as to whether it should be of suffice to comply with the law of the place where the contract is concluded. However, that place is determined, or whether it should be necessary to comply with the requirement of the law of both places. Some commentators have agreed in favor of the latter option. Wolf, for example, stated, "The contract is completed when the acceptance of the offer of marriage is dispatched. Can it be inferred for this that it suffices if the law of the place where the acceptance was dispatched permits marriage by the correspondence? Certainly not. The marriage contracted depends to valid declaration. It is therefore necessary that marriage by correspondence should also be admitted by the law of the place where the offer is staying at the time when he sent his offer." B. Proxy marriage. Proxy marriage are permitted by several countries. The characteristic feature is that one or both of the contracting parties are not personally present at the celebration. The consent of the absent parties being delivered by specifically authorized agent, or proxy participating in the marriage ceremony on behalf of his or her principal. The argument in favor of this point is that it is the consent of the party which makes a marriage, and that the appointment of proxy is the key manifestation of the consent rather than the proxy mechanical execution of this principal's order. Nevertheless, the practical problems which this approach would entail make it an attractive solution. C. Marriage by habitual and repute. Marriage by habit and repute present particularly intractable problems so as far as the place of contracting is concerned. They spring from the fact that of their nature, this marriage cannot be created instantaneously and require the passage of some specific period of time before they are established. The Lex Loci Celebrationis and the problem of time. In referring to the question of formal validity to the Lex Loci Celebrationis, it is sufficient merely to state that the Lex Loci Celebrationis determine the issue. This lex is not static conception, but it is changing body of rules. The choice of rule must therefore not merely point to a particular legal system. It should tell us at what particular moment in its development is such reverse to be made. exceptions to the general rule of Lex Loci Celebrationis. Whatever the general rule may be, whether the inevitable domicile or intended family home, it is clear that it is subject to a number of exceptions. Let us consider them in turn. In view of the paucity of Irish decision, it is difficult to state with confidence whether this exception would command full support. 1. The rule in the Sotomayor versus de Barros. Under the rule in Sotomayor versus de Barros, a marriage celebrated within Britannia where one of the spouses is domiciled in one of the constituent jurisdictions will be valid in spite of the fact that the other spouse do not have the capacity under his or her domiciliary law. Sotomayor versus de Barros, number 2, has received generally unfriendly reception in Australia, falling short, however, of outright rejection. A leading authority has submitted that if directly confronted with this decision, the High Court would not follow it. 2. Incapacity by the Lex Loci Celebrationis, where this is also the Lex Fori, where a marriage is valid or otherwise effective by the personal law of the spouse but void by the Lex Loci Celebrationis, and the Lex Loci Celebration is foreign. Then it will appear that Irish law should ignore any disability under the Lex Loci Celebrationis. The only case in which the contrary has been suggested is the much criticized decision of Breen versus Breen, where Karminski J. looked to the Irish law as the law of the place of the celebration, where the Lex Loci Celebrationis is also the Lex Fori. However, it has been strongly argued that a marriage valid by the parties' personal law or laws, but void by the Lex Loci Celebrationis, will be considered void. There is no clear authority of this issue here or in other common law jurisdictions. The policy justification would seem to be that the forum should be entitled to protect its own law from deficiency by outsiders who came to the forum to marry. 3. Capacity to marry after a divorce. There is some considerable uncertainty as to the position regarding capacity to marry after a divorce, so the present analysis is necessarily a tentative one. At common law, it appears that a capacity to enter a second marriage is determined on the same principle as a capacity to enter a first marriage. Namely, capacity to marry is governed by the law of each party and a nuptial domicile. Two separate questions may arise. First, is the dissolution of the first marriage recognized under our law? And secondly, did the parties have capacity to marry under each party's domicile? In some cases, the questions will seem to be interlocked, so that the answer to the first will appear to dictate the answer to the second one. Thus, for example, if X domicile in Ireland obtained a divorce in England and immediately thereafter remarried in England, we are tempted to conclude that because the divorce is not recognized in Ireland, the country of domicile neither will X second marriage be recognized here. In this example, since capacity to marry is determined by a person's antenuptial domicile, it is in the case that X second marriage will not be recognized, because X was at the time of the second marriage domicile in Ireland. If we vary the fact somewhat, however, the issue will emerge more clearly. Let us take the case of Y, who when domiciled in Ireland, obtained a divorce in England, who remarries in England, not immediately but some time later, by which time Y has acquired an English domicile. Clearly, the divorce will not be recognized here, but equally clearly the second marriage, let's assume, is a valid marriage according to Y and a nuptial domicile. There's an important Canadian case which holds that a marriage should be recognized where valid according to the nuptial domicile, even though preceded by a divorce degree which was not recognized by the law of the domicile of the party concerned. As may readily be appreciated, some difficult consequential questions arise from severing the question of divorce recognition from that of a capacity to remarry in this way. It will be necessary to determine whether the recognition of the validity of the second marriage necessarily extinguishes all the rights and obligations relating to the first marriage. The converse position arises where, following a divorce granted under the law of the domicile, a party marries in circumstances where the law of his new domicile at the time of the marriage does not regard the divorce as effective. There is English authority which is not directly in point, but which would suggest that the validity of the second marriage should not be recognized since its conflict with the nuptial domicile. Later English decisions are, however, difficult to harmonize with this approach. 4. Public policy. It's clear that the court should not give effect to capacity or incapacity under the law of a marriage, under the law of a party, unenuptial domicile, if to do so would be contrary to Irish public policy. The Hague Convention on Celebration and Recognition of the Validity of Marriage in 1978 sought to create a mechanism by which marriage entered into anywhere in the world would be widely recognized, and did so by making the choice of rule Lex Loci Celebrationis. Foreign marriages are one of the concerns of private international law, addressing 1. Whether a foreign marriage is valid, 2. The extent of recognition of marriage or union within the nature of marriage. The primary issue of the Lex Loci Celebrationis is where 1. A declaration of validity and 2. Annulment. The incidental conditions in the Lex Loci Celebrationis is when A. Dissolution, B. Revocation of will by marriage, C. Inheritance of spouse or child, D. Legitimacy of child, E. Taxation relief of spouse. The rule in the Travers versus Holy probably has the effect that a foreign degree of annulment will be recognized at common law if at the proceeding were commenced the applicant was ordinarily resident in a foreign place. Travers versus Holy in 1953. Fact: Woman in a New South Wales and her husband deserted her. H had English domicile and returned to England. Wife sought to have divorce in New South Wales. New South Wales had legislation to overcome CL problem, which allowed wife who had been in jurisdiction for 3 years and had been deserted to obtain divorce. New South Wales readily divorced. When wanted to have divorce recognized, England said the rules for recognition of divorce was lex domicile. Woman's domicile follow husband domicile. Divorce not in accordance with law of England, in accordance with the law of New South Wales. English legislation had exactly the same exception as in New South Wales. Held on the basis that England had the same exception to the rule as New South Wales did, the English court recognized the New South Wales divorce reciprocal jurisdiction capacities. They effectively became the CL rule as long as the representable basis recognition of divorce and annulment. The foreign court need to have assumption jurisdiction on the same legal ground as the foreign court could. Circumstances before the foreign court need only be such would permit the foreign court to exercise jurisdiction. This rule also applied to annulment. Irrelevant that the foreign court did not have jurisdiction to determine similar proceeding at the time the foreign court made the decree, indica versus indica do not have to reciprocal substantive ground, it must be reciprocal jurisdiction. Here is the indica versus indica case in 1969, 1 AC 33. Fact: Test woman married to Englishman. W lived in Czechoslovakia and obtained a divorce there and simply wanted a divorce recognized in English. Problem was the English court rule for recognition of divorce was lex domicile, had to be divorced according to the law of domicile. In 1969, married woman followed domicile of husband, so she had an English domicile even though living in C. Held: if English choice of rule is lex domicile has to be divorced according to the law of England. As soon as court recognizes this sole problem, we apply this rule. New rule placed by which person who seeks to have divorce recognizes a real substantial connection with the place that gave them the divorce. We recognize divorce so long as you obtain it from a jurisdiction where you have a real and substantial connection. Domicile may be real and substantial connection, but could be somewhere else. This has been extended as CL, so not only will be recognized a divorce obtained in a place where you have a real and substantial connection, but if the place where you have a real and substantial connection recognized a divorce obtained in another jurisdiction will also recognize that divorce. Like hermitage, but don't require domicile, just real and substantial connection. This is the case between Yuni Sahara and Kendry Tan. The case of interfaith marriage that occurred was the marriage of Yuni Sahara and her husband Kendry Tan finally managed to register the marriage in Perth, Australia on August 7, 2002. 4 days later, the couple registered their marriage in Indonesia. In this case, it was found that most of them were denied by the Department of Population and Civil Registration to register their marriage in Indonesia, so that they chose to carry out the marriage abroad. The attitude taken by the Department of Population and Civil Registration officer did not detract from the interpretation of Article 2, Paragraph 1 of the Marriage Law. Article 2, Paragraph 1 of the Marriage Law as a condition recognizing the plurality of marriage law according to the existing religion in Indonesia. In accordance with the article, in Indonesia there is a plurality of marriage law according to Islamic, Christian, Catholic, Buddhist, Hindu, and even Confucian law. In the previous explanation, it is known that certain religious laws absolutely prohibit interfaith marriage. For example, Islamic law that prohibits marriage of different faiths. The implementation of the marriage of Indonesian citizens of different religions that are held abroad can be made possibly by the form of legal awareness activities from the rule applicable in the marriage law. On May 21, 2008, Uni filed for divorce against Kendry. On June 17, 2008, Uni officially divorced from Kendry. The second case is about two South African citizens. The case starts with on 5th of March 2015, the plaintiff, who was a South African citizen who had moved and lived in Indonesia, Bali, filed for divorce in Denpasar District Court. The defendant is a woman who is a South African citizen and also resides in Bali. They were married in South Africa on December 12, 1975, based on a marriage certificate on December 12, 2005. The certificate was issued late. The marriage took place in a Christian Catholic manner. We know that the plaintiff and the defendant do not have children during their marriage. They cannot live in harmony and have not lived in the same house for 10 years. Denpasar District Court has the authority or jurisdiction to examine and adjudicate the divorce lawsuit case based on formal and material laws that apply in Indonesia because, first, considering that in Article 207 of the Civil Code, it is stated that a claim for divorce should be forwarded to the state court, which is within its jurisdiction, as the letter of a request revert in Article 831 of the Civil Procedure Law developed. The husband has a place of residence in the absence of such home. The actual residence, if the husband at that time did not have a home or actual residence in Indonesia, then the claim should be forwarded to the state court where the wife is actually living. 2. The Book of Sudardo Gotama, Netherlands, in Indonesia, Burgerlijk Wetboek, is not differentiated according to citizenship measurement. The nationality of the parties is not stated. As is known, in Indonesian civil law system, citizenship measurement is not used. The one Indonesian civil law system used is the classification of the people. Third, Burgerlijk Wetboek Article 1 stated that enjoying civil right does not depend on the state or domicile, where this is understanding require a certain stability in time and intention to settle in a certain country. That is if someone has settled for a period of time which is considered to be long enough, such as 1 to 3 years in a country, then in that place or country it can be said that someone already has his habitual residence. 5. With the divorce lawsuit between foreign nationals in Indonesia, as can be seen from the Supreme Court decision number 2840, which basically stated that the DKI High Court, through its decision number 141 and South Jakarta District Court decision number 47, is not wrong to apply the law in trying divorce case between US citizens who are domiciled in Indonesia. So in this case, the Denpasar District Court has the authority and can adjudicate the case based on the reason above. Third, this case is between two Americans. The plaintiff and the defendant had a marriage on 33rd May in 1997 in Philadelphia, United States, recorded in marriage certificate number D.71700, issued by the Clerk of Orphans Court Division of the Court of the Common Philadelphia County, Pennsylvania. In the marriage, a daughter named Lala Rose Kine, an American citizen who was born in Jakarta on December 24, 2001. The birth certificate was registered at the Jakarta Civil Registry Office and registered with the U.S. Embassy in Indonesia. After marrying the plaintiff and the defendant lived in and settled in Indonesia since 2000, but over time, disputes and quarrels accompanied by physical and psychological violence and neglect in the household resulted in the plaintiff launching a divorce suit through the South Jakarta District Court. About the authority to judge. First, the plaintiff and the defendant had lived together since 2001 in Jakarta, Jalan Taman Patra, number 15, Kuningan, South Jakarta, based on a limited stay permit or KITAS. Second, based on the provisions of Pennsylvania Consolidated Statutes Title 23, Domestic Relations Part 4, Divorce Chapter 31. Preliminary provisions in point B that the Court of Philadelphia, Pennsylvania, United States of America adheres to the principle of bona fide residence, namely to file a lawsuit, then one of the parties must reside at least 6 consecutive months in Philadelphia, United States of America. This provision cannot be fulfilled by the plaintiff because the plaintiff and the defendant domiciled in Jakarta continuously since 2001 until now. The Judge of Council of the DKI Jakarta Court believed that based on the divorce law of the state of Pennsylvania, it can be concluded that the divorce law adheres to the principle of domicile or habitual residence. So if compared to the original plaintiff and the appellant's original defendant, no longer domiciled in the state of Pennsylvania, if filing for divorce, in the principle, the law applicable where the parties are domiciled thus because the parties are domiciled in Indonesia. Indonesian law must be used by the judge in Indonesia. In casu, judge of the South Jakarta District Court. So in this case, the Jakarta District Court has the authority and can adjudicate the case based on the reasons above. A Philippine woman got married to an American husband in the US about 3 years ago. Their marriage did not work out, so the woman decided to go back to Philippines. She has not seen her husband since then and haven't heard of him. They don't have enough funds to go back to the US to secure a divorce. Right now, the woman has a boyfriend who was also working in the US. The question is about 1. Will the woman be forever married to the husband? Can she marry her boyfriend in the US? Second, can her file an annulment of marriage here in Philippines even if she did not register her marriage here? Before we go with her query, there's a need for us to discuss the pertinent law applicable to her question. Article 26 of the Family Code stated that all marriage solemnized outside the Philippines in accordance with the law in force in the country where they were solemnized and valid they were as such, shall also be valid in the country, except those prohibited under Article 35, 36, 37, and 38. When a marriage between a Filipino citizen and a foreigner is validly celebrated and a divorce is thereafter validity obtained upon by the alien spouse, capacitated him or her to remarry the Filipino spouse, shall likewise have a capacity to remarry under Philippine law. The marriages that are prohibited under Article 35, 36, 37, and 38 of the said code are those contracted by any party below 18 years of age, bigamous or polygamous marriage, marriage under contracted through mistake of one contradicting party as to identify of the other, incestuous marriage and marriage contracted by any party who at the time of the celebration was psychologically incapacitated to comply with the essential marital obligation of marriage. For the foregoing provision, it is clear that if a marriage is celebrated abroad, it can also valid here in Philippines, Lex Loci Celebrationis. In this case, provided that her marriage with her American husband is not among those mentioned in Article 35, 36, 37, or 38 of the Family Code, the doctrine of Lex Loci Celebrationis comes into play. Applying the rule, her marriage with her husband is valid and it is binding upon her, even if her did not marriage in the same here in the Philippines. Her marriage has been validly celebrated in the United States of America and thus is recognized by the Philippine law under the doctrine of Lex Loci Celebrationis. Any consequence of her marriage validly celebrated abroad will not bind her even in the absence of the registration with the Philippine National Statistic Office. Since her marriage was done in USA, The registration will be there unless it had been solemnized her in Philippine consulate. Annette her query whether her will forever be married to her husband, the answer would be depend on attending circumstances. Her intention of getting married to her present boyfriend will have to wait and because her still have a valid and subsisting marriage. Any marriage subsequently celebrated without the first marriage being severed will be null and void. To avoid further problems, she must first settle the issue of marriage birth before entering into another one. A person who domiciled in Scotland and a person habitually resident in France, both being of the Islamic faith, go through an Islamic marriage ceremony in Pakistan, where their respective families originated. The ceremony is not registered in the Pakistani authority, but they initially established a matrimonial home in Karachi. After a year, they returned to Europe for immigration and other purposes. Whether they are now husband and wife would be referred to the law of Pakistan, because this is the most immediate relevant law by which to decide precisely the nature of the ceremony they went through and the effect of failing to register it. If the ceremony was in fact sufficient to create a valid marriage under the Pakistani law, and there are no public policy issues raised under their personal law of lex domicile or habitual residence, and under the lex fori, they will be treated a valid marriage for all purposes. It will be in a ramp outcome. Sui Hua Novina versus Chandra Michael Setiawan, a Hong Kong citizen married H, an Indonesian citizen, in Indonesia in 1978 and lived there until 1984. When W left with their child for Hong Kong, W subsequently left for Canada in 1986 and became a citizen there. H had commenced divorce proceedings in Jakarta in 1986, and W was not present when the court granted a divorce in 1987. In the decree, custody of the child was awarded to W, and H had agreed to pay monthly maintenance for the child. In 1991, W commenced proceedings in Singapore against H, who was then a permanent resident in Singapore, asking for maintenance for herself and the child. The High Court dismissed W claims on the basis that the power to order maintenance for a former wife or a child of dissolved marriage was ancillary to the matrimonial jurisdiction, which could not be invoked in this case because the Indonesian divorce decree was not recognized in Singapore. Such power cannot be invoked when there is a voiding divorce or nullity decree preventing the invocation of the matrimonial jurisdiction. The sense of the lacuna in Singapore law is defined by the extent to which the matrimonial jurisdiction of the Singapore court is ousted. By the recognition of a foreign status decree, the legal trend in Singapore show the facilitation of the greater recognition of the foreign decree. The question of the recognition of Singapore matrimonial decree in Singapore is today governed entirely by common law principle. A foreign matrimonial decree will not be recognized if it originated from a court of competent jurisdiction and it is not otherwise impeached for fraud, breach of natural justice, or contravention of the fundamental public policy of the forum. Under Singapore law, the foreign court will be regarded as jurisdictionally competent if it's the court of the domicile of either party to the marriage, or if the foreign court had assumed jurisdiction on the fact that if that had been transposed to Singapore and the Singapore court would have assumed matrimonial jurisdiction, or if there is a real and substantial connection between the foreign country and either party to the marriage. These grounds are not necessarily exhaustive, as the court have not been asked to consider whether residence of either party, where it does not also fall within the reciprocity or the real substantial connection ground, would be a sufficient jurisdictional basis. Even without further expansion, the established grounds of recognition are already wide. The defense to recognition, on the other hand, will remain narrow as long as the Singapore court continues to take the approach that it will be reluctant to criticize the standard of justice applied by a foreign court. And this trend appears very likely to stay if recent authorities outside the family law context on the amount of respect to be given to the pronouncement by foreign court or any guide. While this means that the court in Singapore are taking laudable broad-minded approaches toward the recognition of foreign matrimonial pronouncement and thereby avoiding as much as possible problem limping marriage on one-side effect is that the scope for invoking the court on matrimonial jurisdiction is thereby restricted, and with if it is the power of the court ancillary to such jurisdiction. As a matter of policy, however, it is not desirable to narrow the ground of jurisdiction competence for the foreign court or to expand the scope of defense in order to allow the greater scope for the use of the ancillary power of the local matrimonial justice. It is simply the wrong tool. Under the Women's Charter, the court may order a parent to provide reasonable maintenance for his or her child. Although the child's entitlement to maintenance in this provision is a substantive right conferred by statute, because it is a right specifically created by statute without any common law intention, whether there is a choice of law in the respect of such a right is a matter of statutory construction, and the current wording appears to leave no room for application of any law but the law of the forum. The jurisdictional scope of the provision is unclear. On the face of it, the Act applies to all persons or domiciled in Singapore. It is not clear whether the jurisdiction to be tested with reference to the applicant, the respondent, or the child, or combined therefore. On the face of it, transient presence of the petitioner will satisfy the test of being in Singapore. Thus, on one interpretation, it was open to the ex-wife in case that Setiawan being in Singapore, having actual custody of the child, to make application against her husband under a provision for the maintenance of the child. But this requires a broad interpretation, perhaps too broad, of the territorial scope of the statute. The territorial scope of provision is ambiguous, and interpretation is consistent with international community may require a stronger jurisdictional link between the forum and the child. Under the Guardianship of Infant Act, the court may, upon application of either parent or guardian appointed under the Act, order the payment toward maintenance of an infant. This appears to be a matter of judicial relief, so no choice of law is applicable. There is no feasible clue as its territorial scope within the statute, but it has been assumed that the statute treats the common law inherent jurisdiction of the court as the ultimate jurisdiction is premised on the child being a national of the state, or being resident or present in jurisdiction at a time. Comments of proceeding. The purpose of the statute is to look after the interest of the child. As such, so the jurisdiction connection is naturally focused on the child. This provision may not be available in a situation like the Setiawan case, where the child was not so connected to Singapore, where the main objective of the Singapore litigation was to deal with the aftermath of a material breakup. Maintenance may also be ordered against parents in favor of children under the Children and Young Person Act, but these are specific to situations where the child is being protected by the court and do not apply to the situation under consideration in this paper. The main argument to maintain this existing legal framework are the policies underlying the natural forum doctrine, finality of litigation, and abuse of process. This concern can be observed in Setiawan case. The court may not sympathetic to W, on the basis that W should have asked for her own maintenance in the Indonesian divorce proceeding and enforce the Singapore maintenance order in favor of the child in Indonesia itself. The attitude of the court demonstrates the downside of the court of forum granting ancillary relief after a foreign matrimonial degree. The court granting the matrimonial degree is in the most cases best placed to make order as to such ancillary matter and to enforce such order. The Singapore court should not allow itself to be used as a hub where parties can have a second bite and ancillary relief after obtaining the matrimonial process decree elsewhere. Neither should the Singapore court be used as an appellate process against ancillary order of foreign court. The Lex Loci Celebrationis is the law of the place of celebration of a marriage. In private international law, this law governs such questions as are formalities required for a marriage, whether or not such marriage is monogamous or polygamous, and possibly what law governs impotence or willful refusal to consummate a marriage. The principle stating that the material validity of a marriage is determined based on the principle of Lex Loci Celebrationis without ignoring the material validity of a marriage specified in the applicable marriage law, where the marriage takes place as well as where both parties come from. For example, if an Indonesian citizen married to a Brunei Darussalam citizen in Australia, then the legitimacy of the marriage is determined by the applicable law in Australia as well as applicable marriage laws in Indonesia and Brunei Darussalam.